SJC-13318, Commonwealth v. Michael D. Schoener.
Okay, Attorney Opperman, whenever you're ready.
Good morning, and may it please the court. Aaron Opperman on behalf of the appellant, Michael Schoener. We are here today because at trial, there was insufficient evidence of the crime charged, and because the court committed prejudicial error in the jury instructions. However, in order to reach the merits or the substance of the argument, this court is first called upon by myself to revisit Marshall v. Commonwealth, and before that Rodriguez, Commonwealth versus Rodriguez, and address what the elements, or specifically what the elements of accessory before the fact to a felony are. At trial, the court clearly conflated the crimes or the theories of joint venture of accessory before the fact and aiding and abetting. This court in Marshall obviously walked back the language of Rodriguez, which held that accessory before the fact and aiding and abetting are two separate crimes. This court decided in Marshall they were not two separate crimes, but more accurately, two separate theories of accomplice liability, one of which, accessory before the fact, happens before a crime is committed, the second of which, aiding and abetting, happens while the crime is committed.
Can't accessory before the fact be a subset of aiding and abetting or joint venture liability?
It can, and I think
that's what the Zanetti instruction says. Zanetti instruction says and gives a myriad ways you can prove aiding and abetting or joint venture, and to include accessory before the fact, and it's punished in the same manner.
I think Zanetti suggests that. Zanetti does not specifically refer to accessory before the fact, which is what makes this case, or the facts of this case, somewhat confusing, because it seems to conflict with some of the language in Marshall, which discusses accessory before the fact and aiding and abetting as if they are on co-equal grounds and not as if one envelops the other. And I think the problem with respect to this case is that the language of the indictment only included half of the statute under which Mr. Schoener was charged. It included procuring, counseling, and hiring, and it did not include the second clause of that statute, which is assisting, aiding, or encouraging. At trial, the court clearly thought that aiding and abetting, or I would say he actually thought the opposite of what Your Honor just suggested, and that accessory before the fact encompassed accessory before the fact and aiding and abetting, and instructed the jury as to both theories as if that's what was charged.
I thought Justice Judge Cosgrove said this is the assist version of aiding of accessory before the fact, correct?
Correct. Yeah, so I think rather than conclude that aiding and abetting...
We have two clauses in the statute. One clause is the assist clause, and the other clause is a more specific hiring, counsel, and procuring.
Correct. And I think the outcome of this question is really only relevant with respect to the sufficiency of the evidence on the element of the act, the actus rea, whether or not the defendant procured, counseled, or hired. The trial court seemed to agree, which is the argument here, that that element was not, there was not sufficient evidence of that element.
Why couldn't the actus reus be the assist version of accessory before the fact?
Again, I think that's what the court is called upon today to determine. The defendant's position is that it's not based on the language in Marshall. However, if the court decides that the actus rea was accurately described by the court, meaning it can encompass procuring, hiring, counseling, assisting, encouraging, aiding. Irrespective of how that question is answered here, there was insufficient evidence of both intent and knowledge. And I think that's really the more important issue in this case, how it applies to both the sufficiency question and how it applies to the erroneous jury instruction question.
The way I read your brief is there are really two issues. One is the sufficiency, which you're going to get to, but just before you go to sufficiency, on the assist theory of aiding and abetting, where did the instructions go awry?
I think on the assist theory that the instructions are fine as to the first two elements in the jury instructions. The act that the defendant was required, or the jury was required to find the defendant engaged in, and the crime that he was procuring, hiring, assisting, or so have you. Where it went awry is element 3, which discusses knowledge and intent, the mens rea, and I think it fell woefully short of what is required by Zanetti, what is required by our Constitution, and what is set forth in the Superior Court model instructions for all joint venture cases. And if you look at the record when I think it's the beginning of the day on which jury instructions are given, there's a discussion on jury instructions, and the court says, I don't think I need to give this big instruction on joint venture as to Mr. Schoener. But that was the theory of criminal liability that the Commonwealth was proceeding
Am I
on.
remembering correctly, though, in response to a jury question, wasn't there a more in-depth instruction?
I would say there was an attempt at a more in-depth instruction. I would not say that it succeeded in being more detailed, in-depth, or explanatory. The question was the element of knowledge, can you explain that in layman's terms? And the court, in discussing the question, acknowledges, I didn't explain, or I didn't say very much about knowledge, and then goes on to say, repeats to the jury, you have to find that the defendant knew, and then kind of changes his course of the direction of his sentence, that you have to find the defendant knew, had knowledge of the kidnapping. So he essentially kind of repeated just what he said the first time, and then I think the only other explanation was knowledge is an awareness of a fact. And while that might be...
what's wrong with that?
Well, while that might be an appropriate description of the term knowledge in a casual conversation, when it comes to a trial on an alleged crime and a legal definition that is insufficient. And this court has provided a definition of knowledge in a joint venture case, and that is a substantial knowledge that there is a substantial likelihood that a crime is going to be committed. And that is the definition that should have been given.
And here, again, you know, I defer to my colleagues who have parsed these elements more carefully in the past than I have, but we have a police officer who's who's, you know, for his drug dealer is running Board of Probation information, driver information that he knows he shouldn't be giving out, right? Then he's giving his gun, holster, and police. I can't remember what else he gave. What else did he give? And handcuffs. I mean, it doesn't.
What did he think he was going to do with it?
Yeah, really.
Well, what the record shows and what was submitted to the jury were his statements and his testimony made during the grand jury, during which he said, I believe
Sure, which
Feeney,
they were entitled to discredit, right? They got that, and they were entirely within their rights to not buy it, right?
Well, sure. I mean, they're within their right not to believe anything any witness says, but that doesn't necessarily speak to whether or not the jury instructions were satisfactory and whether or not there was sufficient evidence. And I would say that although the defendant certainly did things that were not allowed by his employer, and were extremely poor decisions. The question is, did he know that
Can I add
was
another?
going to use these items to kidnap another person?
Well, he also knows that the person he's giving information about is in a love triangle, right?
So,
It starts to, you know,
well, and I think that's the problem in looking at the facts at trial, but particularly on appeal, is that they're all set forth in a 50-something page brief, and they look very close together, but in reality, these events did not happen in quick succession. I think there was the running of the license plates, which happened, I believe the record said, in the summer. And then there was the providing of the driver's license, Board of Probation information, which happened in November. And then there was the providing of the other items, which happened at the end of December.
again, this is in the light most favorable to the Commonwealth, right?
I understand. And I think with respect to the sufficiency argument, I would urge the court to look to cases like Gonzalez, Baxter, where there are inferences to be made about the knowledge of the defendant and the intent of the defendant. But this is a case where the inference that he knew what Feeney was going to do with these items and that he intended that this happen crosses the line into speculation.
He has to know it's a kidnapping. He doesn't, if he knows, if it's ambiguous, that it could be an assault and battery, that doesn't suffice. It has to be knowledge of that crime, correct?
Under state and federal law, and I believe I cited the Rosemont case out of the U.S. Supreme Court that says, in not its holding, but says it within the case that...
I take your argument because it's clear that Feeney has a beef with the victim and that he's asking for documents that would identify him through BOP records or in his photograph. Then we have the items, and the argument is, well, what was he going to do with the items? You know, and similar to Justice Wendland's case where they pull up in the car and the guy gets out of the car and we don't know what's going to happen. But here, don't these items point to a kidnapping in that they are used to impersonate a police officer in lawful authority? That's the only issue I've got. If it was just a beef, we don't know. He could have burned his car down. He could have beat him up. Who knows? But
So I think...
Speak to the three items that are unique.
I think the Commonwealth almost puts it best in its brief, where it argues that the defendant knew that the items could be used for a kidnapping, and that isn't enough to find sufficient evidence that he knew that they would be used for a kidnapping, because it is the case that the items can, in theory, be used for something else. And
But not collectively, because I get the whole issue with the handcuffs and it could be a costume party, but when you put them all together, it's a different issue.
And when Your Honor says altogether, do you mean the three items or the three items coupled with the other evidence?
Well, yeah, well, I mean, the three items, address the three items.
So with respect to the three items, I think that the only answer the court needs to find is that they could be used for something other than kidnapping. And
What?
Well, I think something that would still be a crime but wouldn't be the crime of kidnapping is simply posing as a police officer. One could
Don't you
the
just
crime
need
of
the
posing as a
badge for that? Why would you need the handcuffs and the holster?
Well, you could just use the badge, and, I mean, police officers have guns, they have handcuffs. I mean, so I think if one is looking to commit the crime of posing as a police officer, I mean, they could use those three items, among other things, a gun for one.
Can I ask you what I think is your stronger argument is about the shared intent? Because it seems to me the knowledge issue is not your strongest, but can you talk to me about the evidence of shared intent?
I think it's similar. I think they are overlapping in many ways.
You have no difference in the arguments.
I
Focus on the difference, if any. Because if you don't see any, then that's fine by me.
I don't know that they're entirely different. I would make the same arguments as to knowledge, but I think with respect to evidence that shows his intent, what the court has instructed courts or trial courts or juries look to with respect to sufficient evidence is a motive, whether or not a defendant sees a joint venture or an accomplice develop their intent and thereafter acts to help them. And I think the case that is probably closest on point to this case is Commonwealth versus Stout, where the court holds that someone who delivers guns to an individual who later robs a bank is guilty of the principal crime. And the reason that he's guilty is because the evidence showed that a couple of days before the crime, he was with the accomplice while the accomplice discussed what he was going to do with the guns. And that is the piece that's missing here.
I think Judge Cosgrove said, boy, this is a close case. You know, excuse me, I think it is. Getting back to your first argument, what was his instruction on intent?
I believe that the instruction on intent was simply that the only thing the Commonwealth must show is that the defendant had knowledge of the crime and shared James Feamy's intent to bring it about. The intent to commit kidnapping is the intent to confine or imprison another person against his will. The requirement is satisfied even if the purpose to kidnap in the defendant's mind was simply a conditional or a contingent one, a willingness to see the kidnapping take place if necessary. There was no other instruction on intent, and I would contrast that to the instruction on intent for joint venture.
So your argument on instructions is they weren't as rich or fulsome as the Zanetti instructions?
Correct.
But before Zanetti, we had non-Zanetti instructions, which we said were fine, correct?
Correct. However, Zanetti is so old at this point, I would say it has essentially
It
become
doesn't seem old to me, but
the law of the land. Legal terms, old is just a few years,
Right.
but more so in the number of cases that cite Zanetti as controlling. And I think here, the difficulty with joint venture cases is that the jury needs to understand the intent to commit the crime, but the jury also needs instruction on what sharing someone's intent means. Because,
You know, there's nothing about Zanetti that says the previous instruction differentiating principle in joint venture was wrong. It's just Zanetti is frankly easier to satisfy in a lot of ways, and you don't have the required finding issue of one being satisfied and one not. But there's nothing in Zanetti that says the previous joint venture instruction on shared knowledge and intent was wrong.
I would agree with that, but I would say that the instruction in this case fell short of what is required, what is constitutionally required to explain the issues to the jury.
Attorney
Because-
Ackerman, I need to ask this one question because I know you're well over time, if you wouldn't mind. In response to a question that Justice Gaziano asked you, you said either the knowledge or the shared intent with respect to looking at the three items or all of the other evidence, and you only answered the question with respect to the three items. But were the jury able to look at all of the evidence when determining knowledge or shared intent?
Of course.
Okay, so if that's said, what about the call after the fact about, did you have anything to do with this, going to retrieve the items? How does all of that not militate in favor of sufficiency?
Well, I would say the call, I believe, and I'm not as confident on the timeline of this, I believe the call happened around February, so a month to 2 months after Mr. Robertson went missing. And there was a statement.
But when did he retrieve the items?
I believe the record was that he retrieved the items on the day after the kidnapping took place.
Wasn't it 3:30 on that same day?
It was either the same day or the day after. yes. And so obviously, that is something the jury could consider. But again, I think with respect to both knowledge and intent, and Your Honor is correct that the question on knowledge is closer than the question on intent, there is still the question about whether he knew what the items were being used for. He certainly knew the items were borrowed. So the fact that he retrieved them is to be expected. But this court still has to look to what evidence shows that the defendant knew what the items were being used for and intended that they be used that way. And there's certainly evidence that doesn't look good. This is, as the court suggested, I mean, it's a sufficiency argument. It's not beyond a reasonable doubt. It is a somewhat close call in the grander scheme of criminal trials, but there does have to be, and this court has said repeatedly with respect to joint venture cases discussing whether or not there's sufficient evidence on intent, there has to be more than just speculation. There has to be the observation of a conversation discussing a crime. There has to be evidence that the defendant overheard the principal saying, I'm going to do X, Y, Z to this guy. And that wasn't there. There was evidence that he was aware of some animosity. There was evidence that he was aware that Mr. Feeney did not like Mr. Robertson. There was also evidence that he never thought that Mr. Feeney could have or would have done this in part because he was in a wheelchair. And it didn't cross his mind that someone who was handicapped would be committing such a horrible crime. I think the jury also heard everything that the witness, Andrea Morse, knew about. She knew much more about Mr. Feeney's disdain toward Mr. Robertson, knew and had told him that Mr. Robertson was acting as an informant, knew more about the weapons that Mr. Feeney had, and after she found out what Mr. Feeney had done, still expressed doubt that this could have happened or that he could have done this. So I think taking a step back from the pieces of evidence here, what this court should focus on is simply that there are inferences to be made, but that's all that's there. And in this case, that's simply not enough.
Okay,
If there are no further questions, thank you.
thank you. Attorney Alford.
Good morning, Your Honors. The Commonwealth asks this court to affirm the defendant's conviction for accessory before the fact to kidnapping, involving the kidnapping of James Robertson, whose family is in the courtroom today. The defendant, a police officer who had previously provided his drug supplier, James Feeney, with the victim's criminal record and license photo, gave at Feeney's request his police badge, handcuffs, and a holster, although he said he was taken aback at the request. Items whose very purpose in non-police hands would be to falsely assert lawful authority to restrain, and tools which the jury could find were instrumental to the victim's kidnapping.
So would you just focus on the knowledge and intent issues that were talked about previously?
Absolutely, Your Honor. These two elements are intertwined. Mere knowledge is not enough, and the Commonwealth suggests, particularly here, the shared intent builds on the knowledge of the whole relationship between both the defendant and Feeney and the defendant's knowledge of Feeney and the victim. So starting, the defendant was a police officer. Feeney became his drug supplier. He said the defendant, whose grand jury testimony was read into evidence, said that he went to Feeney's apartment 2 to 3 times a week for pills, stayed 15 minutes. They were friendly. That he would occasionally wear his police pants, which was corroborated by another witness to Feeney's apartment. So Feeney clearly knew that Schoener was a police officer. Schoener said that he knew there was a love triangle there. Schoener said that, the defendant said that, Feeney started talking about his anger was directed towards Morse, that she had left him.
I'm sorry, let me refocus.
Yep.
I want you to address the knowledge that there would be a kidnapping.
In the Commonwealth suggests it's the whole relationship, so.
Good, so
Yep.
he knew about the love triangle.
Right. He knew that Feeney disliked the victim, and I suggest it's not casual. I suggest it was repeated. He said he mentioned him a few times. The victim came to Feeney's apartment at one point at the parking lot, got himself arrested.
Counsel, let me ask you a question. What if it's equally plausible that somebody were to take those items, understanding that Mr. Feeney was not happy about Ms. Morse's relationship with Mr. Robertson, and somebody with those items goes by and sees Mr. Robertson and says, "Hey, Mr. Robertson, stay away from Andrea Morse," and then drives away. Why isn't that equally plausible versus a knowledge and shared intent of a kidnapping?
Because he wanted his police handcuffs. The there is testimony.
That's all part of the standard issued uniform, though. I mean, if you would come across a police officer, they've got the badge, they've got the holster, they've got the handcuffs. It all adds to the appearance. And again, the question and the concern that I have is the question of, is it a bridge too far? That the shared intent and the knowledge of a kidnapping that leads to a terrible murder of another human being, but the question is whether the jury could find that beyond a reasonable doubt on this evidence.
And the Commonwealth suggests that it can, because the important here was that the defendant knew that Feeney had handcuffs, and yet Feeney wanted the defendant's police-issued handcuffs. There's something to be made there. He wanted his badge, which gives somebody lawful authority to direct other human beings, a critical component of intent. He wanted his holster, from which the defendant could infer that a firearm would be involved, and he wanted his police-issued handcuffs, an item whose very intent, very purpose is to restrain, the core element of kidnapping.
I know, but I think this is the question. There's no doubt that what the defendant did here was disgusting, appalling. That's not what we're talking about. The challenge is, after the crime's already been committed, you can put pieces together and say, yeah, he knew that it was going to be a kidnapping. But the question is, did he know that something untoward, really appalling, was going to happen? Why is it that it was a kidnapping?
Because the Commonwealth suggests, the defense appellate counsel makes a lot of comments that there wasn't direct communication. There was direct communication here. When the initial conversation, when Feeney asked the defendant for these items, and at the grand jury testimony, it went item by item. First, the defendant says, "I was taken aback." So he knows this is important. He knows this is a big deal. He knows this is not within the common knowledge of what one would normally, I suggest, legally do with these items. Two, as to the badge, and this testimony was specific. The question was, did he say what he was going to do with the badge? And the answer was, "Oh, I just want to use it." That's a direct communication. He's asking for these three items at the same time that he wants to use. And the defendant says, the defendant who has knowledge of the animosity of of Feeney's wanting to track the victim by asking for his border probation record so he could see what he was up to, for his license information, and then shortly thereafter getting 15 pills as a Christmas gift, then says, knowing all of this, you know, he didn't really question Feeney on the rest of it because he wanted to keep his drug connection open.
Yeah, so that's my issue, is that you say that on the one hand because he wanted to keep his drug connection open, and yet you have to show that he shared Feeney's intent to kidnap.
And, Your Honor, the Commonwealth suggests that this is an apathy or a willful disregard, that with knowledge of the circumstances, the defendant here knew what was likely to happen, or substantially likely to happen, and did not care that it would happen because he had a different motive. That is shared intent if you look at Commonwealth versus Richards as to conditional or contingent intent. That if you look at Commonwealth versus Paget, an appeals court case, which says it's not that the defendant had to have wanted this to happen. In fact, the defendant may have not wanted a shooting to happen. But with the knowledge that the defendant had, he shared the intent that it was conditionally or contingently possible for this to happen. And to address a point that this is not a case where there needs to be another crime for conditional or contingent intent, pointing to Commonwealth versus Erickson, another appeals court case where the defendant wanted to send images to a 16-year-old, graphic images to a 16-year-old, but wanted her to send them to him first. The appeals court noted that the intent to disseminate was still there, even though it was a conditional or a contingent one. And this goes back to case law from this court, Commonwealth versus Richards. And therefore, you had both the knowledge that the defendant was looking to use these items to restrain somebody unlawfully, and the intent that the defendant here was okay with that.
Let me ask you two questions. You proceed on the procure theory, not the assist theory?
So the indictment came from this court's footnote, I think it was footnote 10 from Rodriguez, of the new statutory form of the indictment, which had come from 277-79. The Commonwealth asked that the statutory language of procuring, hiring, and procuring, counseling, or hiring be read. And 2 points to be made here. One, the judge's comments that appellate counsel makes a lot of weight of here didn't come from a directed verdict finding. This came from musings on the jury instructions. And there was a lot of discussion about what procure meant. And I suggest where the parties fundamentally differ here is on the narrowness of the word procure. The Commonwealth suggests that...
I don't know if I agree with you on whether procure, but are you disavowing the assist theory of accessory before the fact?
No, I suggest the assist theory is part and parcel of counseling, hiring, or procure. That if you look at accessory before the fact, and if you look at Marshall and Rodriguez, that case suggested that there was actions that happened during the crime, and they talk about aiding, being physically present during the crime, and then actions that happened before the crime. And Marshall makes clear that these are two means to the same end. And the Commonwealth suggests if you look at Raposo and you look at cases going back to the common law, it all goes back to the same point that for accomplice or joint venture liability, you need knowledge, intent, and a significant act of the person who is the accomplice or the joint venturer.
More specifically, because counseling and hiring seems pretty obvious, but procuring such felony to be committed, you say, encompasses the assist theory.
I would suggest counseling includes the assist theory, and that goes back to Commonwealth versus Francis, where this court found clear enforceable instructions defining counsel, including to assist, to encourage. Procure is not nearly as narrowly read as cause and effect. There's cases such as to procure alcohol. Procuring can be an item of great importance. And here, the defendant said he was taken aback by the defendant's request for his lawfully issued police items to be used by his drug supplier. That procure can also that procure in counseling and hiring are all assistance type verbs that go to actions a party may take prior to the offense which distinguished this case from Marshall and Rodriguez, where the very issue before the court.
So when I look at 274, Section 2, in the two clauses, your position is whoever aids in the commission of a felony is just straight joint venture, and then the second part, or is an accessory before the fact, just describes accessory before the fact liability.
Under Marshall, I do think this.
Yes or no?
Yes, this court made clear it has to be before the fact, and that was the very linchpin of Marshall.
Right, yeah, that's the before the
Right.
fact. Right, but let me ask you my second question. The judge made a finding, I forgot the nature of the crime on the directive verdict standard, that this was more of a prank.
I don't think that the judge made that finding, Your Honor. Could you?
I thought the judge said this could be a prank.
I don't know, that is not my memory of the record, Your Honor. My memory of the record is he clearly found that this was a close case, but that the inferences before the jury were sufficient to.
I'll look at it again, I may be wrong.
And
I thought at one point Judge Cosgrove said it could be a prank.
And I also want to note, Your Honor, that there was a 25B2 motion here where this very same issue was raised again. So to the extent there was any concern, issue about Judge Cosgrove's reasoning, the Commonwealth did include that in the addendum, and he found that this met the statute of 274, Section 2.
The defendant did say, though, in a second interview, that he thought this was all a joke, and that statement was not allowed in substantively. So there was an issue. This is one of the issues in the appellant's brief.
So I think that is cumulative of grand jury testimony that, and again, the defendant here had the opportunity.
Well, so what? Because you impeached one way, you can't impeach with a second statement?
So going back, so as to the third issue, this wasn't an impeachment of the officer's credibility. The officer was certainly entitled to be impeached over the fact that he testified that the defendant said he did not want to know what Feeney wanted the items for. He was certainly entitled to impeachment that was not in his police report. What the defendant here was trying to get statements that the judge found to be similar, that he didn't know from an interview 13 days later after he had been arrested. These were being submitted for their truth, not for impeachment.
That's a fair point. I mean, that was not suggested as impeachment evidence at trial. It was suggested for its truth, its state of mind, which it obviously didn't fit. And did they raise the issue of doctrine of completeness at trial?
They did. I believe it was raised in a motion of limine. It was an abuse of discretion standard. But the judge quite properly found that these were, or certainly the Commonwealth would argue, 13 days apart and after an intervening event of an arrest, self-serving statements were just that.
Well, it's not that they're self-serving, it's a different conversation.
It's a different conversation. It is, Your Honor. If there are no further questions, the Commonwealth asks that the conviction be affirmed.